What is arbitration? How arbitration is different from regular court? Regular courts take years for a dispute to be resolved. Not only that, there is an appellate provision. You can file first appeal, second appeal, and if you are aggrieved by that, you can go up to Supreme Court. So it takes years for attaining the finality. Whereas in arbitration, contracting parties decide that outside the court system, they will go for the adjudication of the dispute. Now, that award has to attain a finality. So, when the arbitrator passes an award, which is otherwise in a common parlance known as a judgment, once that award is passed, that is final. It will not be further litigated in appeal, and that is how it attains the finality. Therefore, we come to the second question: why arbitration? Arbitration is required for those who require speedy resolution of the dispute. Arbitration is known as alternative dispute resolution. You appoint private individuals or maybe the private institution for the resolution of dispute. So once this institution comes into picture or the individual comes into picture who are otherwise retired judges or well reputed people who are known for their neutrality and integrity, once that happens, the dispute resolution process gets kick started. A usual timeline for determination of the dispute resolution is 12 months from the date of pleadings, whereas it takes almost 5 to 6 years in a common Indian court to get the dispute resolved. So we come to the third question: for whom this is applicable? This is applicable in common business parlance. If your business requires speedy resolution of dispute, it is not a family dispute, it is not a long drawn land dispute, but a commercial dispute. You need quick resolution of the dispute, then arbitration is much suited for you. Now, very next question will be how to enter into an arbitration agreement and how to invoke the arbitration. So these are the two separate limbs. Rather than going for the dispute resolution to common court model, how would you go to the arbitration? The first and foremost requirement is that you have to sign an agreement, and that agreement has to have a specific clause that in case of a dispute, we will refer the dispute to arbitration. Once this modality is decided, courts get ample power to appoint an arbitrator even if both parties are not agreeing to the name of an arbitrator. And that is how the arbitration machinery is put into motion. Now, how the awards of an arbitration court are enforced. The awards of an arbitral tribunal are enforced just like the decree of any other civil court in India, and therefore the journey of litigation is quick. However, the enforceability is same as if it were a decree of the civil court, and that is how the arbitration becomes a very lucrative and quick mode of dispute resolution when it comes to the commercial parlance. Now, one important statistic: in 2015, India reformed its arbitration framework like anything, and because of this reform, the rank of ease of doing business in India jumped from 142nd position to 63rd position. India is doing a lot of other reforms which is taking India to its journey on a higher spot in the dispute resolution hierarchy as it comes to the arbitration. A common question is, where is the seat of an arbitration? Because those who do not know about the arbitration, they have a natural question that if there is a dispute, there is a civil court in my city, I will go to that court and the lawyers will be arguing my case. There will be a judge sitting into the court. But when it comes to arbitration, there is a question where these arbitration proceedings will be conducted. Now, the answer to this where is in two parts. There is one aspect that is called the seat of the arbitration. Second part is the venue of the arbitration. Now, venue could be virtual also, it could be any place. It could be India, it could be outside India, but venue doesn't matter. What is important is the seat that both the parties have agreed for all purposes. Because suppose if you have decided the seat of Ahmedabad as a seat of arbitration, then for all supervisory purposes, all procedural purposes, it is a very important aspect. Because once the award is passed, if the party is aggrieved, then the party would like to invoke the Section 34 jurisdiction. So which court will have the Section 34 jurisdiction? That will be the Court of Ahmedabad. Then naturally, if that application's order is not agreeable, where would you file the appeal? That appeal you can file under Section 37, that will be Gujarat High Court. So to determine the supervisory powers over the entire arbitration process, seat is a very important concept, and therefore while signing the arbitration agreement, Not only that, you should have a valid arbitration clause, but you should validly define the seat of the arbitration in order to have proper supervisory powers as well as to avoid any further litigation as regards to the seat of the arbitration.